Good afternoon, everybody. I want to thank everybody on behalf of the family for last week and respecting their privacy. As you all know, last Tuesday, so April 4, was the one-year anniversary of Loyola's son and brother's death. And we wanted remarks that day to be about the family and what they've been through. And we appreciate that you all respected their privacy. And I promised you about today back then, so you all would know there's been significant developments in the civil case, and we'll share that with you. But before I do, want to make sure everybody knows where everybody is. So on the far right, for you all on my left, is Israel Saku. He's our translator. You've met before. Peter Lyoya, of course, is Patrick Lyoya's father. Mr. Ben Crump doesn't need any introduction at all. And Commissioner Robert Womack from Grand Rapids City Commissioner that's been with us from day one. I also want to make sure I thank folks in our group here as well. Thomas Lyoya is Patrick's brother. Aris Papanao is our associate on the case, along with my co-counsel, Yana Hatchett, Maria Reyna, paralegal, Liza Dodson, paralegal, and Chris Desmond is not here, our appellate attorney. And I wanted you to know these names because for the last 2 weeks, instead of Chris O'Neill, pardon me, Chris, I apologize to you, sir, Ben's right-hand person as well. For the last 2 weeks, we have been responding to motions. So I'm talking now, guys, about the civil case. Real quick, the criminal trial, you all know, October 24, 2023 is the criminal trial. Now let's talk about the civil case. Typically in civil cases, after we file our lawsuit, we ultimately turn over, we get to go to discovery and have depositions and documents exchange, et cetera. Not in this case. Immediately, Schuer, via his counsel, and the city of Grand Rapids, they have independent counsel. They have two different law firms, which is not normally how it's done, by the way. More often than not, they always have one firm representing them both. So that should tell us all something significant. There's already a parting of the ways, at least for now. They filed motions for summary judgment, and that's what we call it in federal court. State court, we call it something different. For those of you here in Michigan with us, you all know about governmental immunity, because we've been talking about it now in context of many cases, but especially the Oxford shooting tragedy. Governmental immunity in the state law claims that we have filed here in Michigan also come into play. I'm not going to go there today, but we have state law, state of Michigan claims in this case on gross negligence and the proximate cause, just like we do in Oxford in this case. So I just wanted you all to know there's a recurring theme that we got. But under federal law, and Mr. Crump will certainly address this for you folks as well, there's even more aspects of governmental immunity. Can't sue the man unless the man says you can, and when he says you can, he don't mean it, all right? There's a couple, right?
Right.
There's a number of different things that come into play, but one of the ones that's important for today is why Schuer filed a motion. Schuer filed a motion asking Judge Maloney, who is a U.S. federal judge in Kalamazoo, where this case is pending, to throw him out of court, this case, our case against him, because he has a constitutional right to shoot our client in the back of the head. And that there was no known constitutional deprivation, meaning I didn't know that it was against the law for me to do that. Okay? That's the motion that they filed. We, for the last month, but especially the last couple of weeks, and the great folks that I've been talking about, have filed our response. And then last Friday, Ms. Hatchett, correct? Last Friday, we actually filed our, what we call responses to the motions from the city and Schuer, where we said, oh no, Judge, this case shouldn't be thrown out of court. This case should work its way to the jury. As part of that motion, we did something incredibly different than what the defendants did. You all have seen the video. I got it fired up today, and because I know you're going to ask me some questions about that, and we're going to talk about that. But in the briefs filed by the lawyers on behalf of Schuer and the city of Grand Rapids, they have a recitation what they think the facts show, what they think the video shows. We didn't do that. Our trial team, Mr. Crump, Ms. Hatchett, Mr. Papineau and I, we went out and got hired experts, state-of-the-art hired experts in the area of what we call police procedures, police misconduct, call you what will. We're going to introduce those folks to you by way of their sworn affidavits. These are all, I'll have copies for you guys if you want them. You want them digitally. They're also online because, as I told you, they were filed last Friday, April 7th. So we have two gentlemen, ladies and gentlemen, today who combined police experience, I think, Ben, of nearly 70, 80 years, okay? Two different ones that have opined in their affidavits that what we saw here was not only gross derivation, not just a complete ignorance and refusal to follow Schuer's own training, but even more importantly for us in terms of what we're going to talk about, that this deadly force was unnecessary and therefore under the law illegal and excessive. And one of the things you're going to hear us talking about today is what that means in terms of our civil case and again, the importance of something that everybody needs to understand, and that is if somebody resists arrest, please someone write this down, please, does not give an officer an absolute constitutional right to use excessive deadly force. It does not. Who will prove that when we go to trial? Sure will admit that when Crump and I ask him on the witness stand. He will admit that he's been trained and he knows he cannot use unnecessary deadly force just because somebody resists arrest. Officers, folks, are trained for this. And they're supposed to follow their training. Another term that you'll hear Schuer and every other cop that's on the stand say, I'm trained to follow my training. When I'm in a tight spot, when I got stuff going on with real people on the real street, I fall back on my training, right, Chris O'Neill? You know that, former police officer. And what we're going to show you today is exactly how that did not happen. All right, so everything that Ben Crump and I will be talking about today with respect to our two experts, again, their affidavit, what does that mean? It's sworn just as if they're under oath, and it's just as if they're in a deposition or in a trial. Let me tell you about Tom Titterington. Mr. Titterington is the expert that I will be talking about, and Ben will be talking more about Mr. Ken Katsaros today. Why do we have them? In every single police misconduct case, excessive force case, police misconduct, same thing in our world. You have the right to hire any expert you want to help you figure out what happened in the case, whether it rises to the level of unlawful, excessive, deadly force. So we hired Tom Titterington and we hired Ken Katsaros shortly after this shooting, so that we could answer your questions and we could obviously present evidence at time of trial. In the criminal case, they will have them as well. Okay? Maybe not these gentlemen, they may have their own. Some of you remember some of the testimony at the preliminary examination in the criminal case that involved a captain from the city of Grand Rapids. That was Schuer's witness. Prosecution witness, at least off the top of my head, didn't call one. And that's Mr. Becker's prerogative, and I am not in any way dogging my brother, Mr. Becker. Good for him. He can do it however he wants. But we wanted the world to know what really happened and what two of the foremost experts in our country had to say. So Mr. Titterington, Tom Titterington, folks, has been in the police business, if you will, for over 44 years. He was a Detroit cop and then ultimately came out to the burbs. And for the last 10, 15 years, he's been chief of police for the Plymouth Township Police Department. Tom is highly decorated. He's been not just the chief of police, he's been internal affairs chief. He's done everything that pretty much anybody can do in terms of police work. And so he is one of our experts. Mr. Crump, do you want me to introduce Mr. Katsaros? Same thing, or you want to handle that?
Yeah, why don't you go ahead and do it, because I want to get to the national.
Thank you, sir. Ken Katsaros, folks, is from Tallahassee, Florida. Mr. Katsaris, and it's Katsaris, Titterington, Tidderington. Mr. Katsaris likewise has been in law enforcement for almost 50 years now. He's was
Yep, my city
Right?
police chief.
well, and Ben's from Tallahassee, Florida. I've known Ken Katsaris. He's handled cases, some of the biggest cases across the country. And Ken works, just like Mr. Titterington works, on both sides. Translation, some cases, the folks who are injured or killed hire him. In other cases, he is hired by, they're hired by the police. So what that tells you is they're highly reputable, highly respected people who don't just mail in their opinions, that review things and are well respected by both sides.
And you may want to tell him, Mr. Casares is hired and retained more by police departments,
Correct.
far more than he is by plaintiffs.
True. Mr. Katsaris, if you were here, to tell you folks that the great majority of his work is not only doing testimony, but he actually does in-service training for the officers. And so he teaches them on every topic that we're going to be talking about here today. So as part of our motion and part of our, I should say, our response, what we asked Titterington and Katsaris to do is to go through the video and to analyze what they believe to be the rights and wrongs of what was done. So why don't we start with that? And for anybody that's interested, we have both of their curriculum vitae, they're both of their resumes. I'm not gonna bore you guys with that, but they're both highly decorated and been doing this forever. All right, on Mr. Titterington's affidavit, for those that get it, I'm gonna start talking about what he says on page 5. Anthony Cairo, I didn't thank you, I should have. Steve Natt, I didn't thank you. Thank you both for being here and all your hard work in this case. Anthony, can you please start the video? Start from the very beginning, because I want to address something that Mr. Crump's going to comment on extensively, and what we have and what we don't have. What you're going to see is the beginning of the video, and what you're going to find out is that there's no video from when Schuer and Patrick were going in opposite directions. Everybody in this room knows we in Michigan have license plates in the back. So if you're going in opposite directions, you can't see the license plate of the other car. What does that tell you? It tells you that the initial following that Schuer does, you're going to see him do a turnaround, he speeds up, he goes around a corner, he catches up to Patrick's car, and then he looks at Patrick's license plate. And if you recall, as we all know, the first thing after Patrick asked him repeatedly, what I do, the only thing that Schuer told him was, your license plate doesn't match your car. Well, Officer Schuer, former Officer Schuer, because now you've been fired because you're being prosecuted for second-degree murder, you didn't know about the license plate when you first started filing these two young black men at 8:05 in the morning on Monday, April 4. So, Mr. Crump, what does that tell you?
And I don't know if you want me to go ahead into,
Do it.
you know, I just want to say this, and I want to come to Peter Lyoya, so everybody can understand why this is an important case to many people, not only nationally, but internationally. He's from the United Republic of the Congo. People in Africa are looking at this case saying, is it allowed in the United States of America for black people to be shot in the back of their head as they're running away from the police? And what Attorney Johnson so ably was breaking down very technically is Michigan law. But we also have to look at this as a national matter. And as you look at Peter Lyoya, almost a year and a week after his son was brutalized by the police, shot in the back of his head. despite everything Mr. Johnson, Attorney Johnson and his great team are going to tell you, despite anything me and my co-counsels from my firm working with Mr. Johnson is going to tell you, this is simply a case of driving while black. And we don't ever need to let that issue get swept under the rug, because our experts are going to tell you there were so many reasons why this was unjustified. But Attorney Johnson and I believe it all would have been avoided had this police officer not profiled this black motorist for driving down the street. The statistics that Commissioner Womack and I were talking about, Attorney Johnson, was the fact that it is 213% more likely for police officers in America to stop black motorists without any justification than they stop white motorists. So this is part of a systemic problem. And I just want to stand to bring everybody's attention back to what this is about. And so the motion to dismiss, as Attorney Johnson and I discussed, is them trying to come up with technical justifications for the discrimination. Nothing more. You don't have to go further than that, but we will. But you can stop there. This was something that was biased, very biased. And everything that follows from that initial pretextual bias stop is bias. It's a violation of that. His training and his policy, and you have to ask yourself why. We don't see videos like this with white citizens. And so before I turn it back to Attorney Johnson, you look at this in the larger context, and that is this police brutality against citizens of color, against people of color. We saw it with Patrick Lyoya. We saw it with Tyree Nichols in Memphis, Tennessee. We saw it with Ivo Otenino in Richmond, Virginia. Black people who are posing no threats to law enforcement. And we challenged them to show in that video where Patrick Lyoya is doing anything but trying to get away from him. And what did he have been? He has flip-flops with his pants hanging down. He wasn't going to get very far. Our experts go through a litany of things he could have done to avoid executing him by shooting him in the back of his brain. And so I so appreciate Attorney Johnson and Attorney Hatchett, Attorney O'Neill going through all the technical fine points, because that's what we have to do. And we understand due process and how they change the rules, and that's what Attorney Johnson is talking about, this attempt to delay in hopes that you all will forget that Officer Shearer executed a young black man by shooting him in the back of his brain as he was trying to get away from him. And that's what we always want to bring everybody's attention to. They want to delay it. They want to not deal with the merits of this case. They want to try to technically justify yet again killing another unarmed black man in the United States of America. Police brutality, and now they're trying to follow it up with political brutality, with this immunity and this motion for summary judgment. They don't ever want to deal with the crux of the matter. But Ben Johnson and I and our legal teams, we're not going to let them sweep his death under the rug. We won't let them sweep this execution. Let's call it what it is. This was an execution. Traffic stop lead to a death sentence by shooting them in the back of the head. And then I do get a little emotional because when you think about 1 year ago, we kind of, so many other shootings have happened, we've forgotten about them. But this is critical because if they can shoot Patrick Lyoya in the back of the head and get away with it, what message does that send to police departments around the country?
And to accentuate something Ben just said, we're going to ultimately argue this motion before Judge Maloney in Kalamazoo, likely. And then there will be a ruling, and assuming he agrees with us, the case should move on its path to trial. You mark my words, we'll have another press conference, and I'll be announcing that now the defendants are appealing to the Sixth Circuit Court of Appeals, which will be another year to a year and a half of delay, which of course then allows the criminal case to go forward in October without us doing the discovery and the depositions that we otherwise would be doing. Welcome to governmental immunity. All right, so on the video, you can see the video showing Schuer in his patrol vehicle, and this is his body camera. Go ahead, Anthony. Stop, and you see this is his on dash camera, so it's right by the area we all know now of his rearview mirror. He's turning around in a driveway. Translation: you don't see the car going the other way. Translation: he had nothing. He had nothing on Patrick Lyoya until he caught up to him and saw what he thought was a license plate issue. Why is that important? Well, it certainly supports 100% what Ben just told you on racial profiling, DWB, driving while black. It also shows you when we address the elements under the law of excessive force, if the underlying offense is a minor offense, that's a huge check, meaning should not ever lead to deadly force. So that is a critical issue. Go ahead, Anthony. Thank you, sir. Now you have Schuer turning around. Now he's catching up, and you can't even see at this point. Now he's turning right. You can't even see Patrick's car. Patrick's car down the middle. Now the lights are on. Now he turns. Patrick sees. And what you're going to see is Patrick pulls over. Okay. Stop, Anthony. The buzzing sound that you just heard now the camera is actually up and running. The mode it was in before is called buffer. We don't need to go there today. But now there's going to be sound, and you're going to see what you've already seen before is the initial interaction. But again, now you can see the license plate. Now we're there. Now we can run a check on the license plate. And if it turns out it's wrong, then it's wrong. But then he has nothing in any of the police records so far. All in these affidavits, our experts have already opined. That means that they've reached the conclusion that there is nothing to support that Patrick did anything wrong until he was suspected of having the wrong license plate, which in our world means there is no reason to follow him and see because there's no allegation of swerving, going too fast, or doing anything wrong. Go ahead, Anthony.
Then north of Griggs, Everett, King Paul, 9367, Dan Alton. Hey, stay in the car! Stay in the car! Stay in the car! Get in the car! Dude, I'm stopping you. Do you have a license? Do you have a license?
For what?
I'm stopping you. Do you have a license?
What that?
Do you have a driver's license? Do you speak English?
Yes.
Can I see your license?
What that you want?
I
The
assume
plate
you
doesn't
also
belong on this car.
speak English.
Yep.
And I'm just going to tell you something that I hope you all would acknowledge. Someone comes up to any one of us and said, "Do you speak English?" with their hands. is a pretty condescending and very disrespectful thing to somebody who also has English as a second language. But what you see, folks are going to say, well, he got out of the car. How many times have we watched videos where the people don't get out of the car and then they get dragged out of the car? Okay? So is there anything wrong with Patrick Lyoya getting out of the car? Answer is no, other than that's not what Schuer wanted him to do. And then Schuer told him to get back in. Now we're going to hear a discussion about that. But as you can see, Patrick has his pants on, and you're going to see he has some type of flip-flops that ultimately come off. And at this point, notice, Schuer has not pulled his taser. Schuer has not pulled his weapon. What does that tell you? That means he's not in reasonable fear for his life at that time. Important information for police to have. Translation, if he thought Patrick had a gun at this point, we would be talking different language. So at this point now, there's the interaction that we've all seen. And I'm going to point out when the first touching occurs. That becomes a critical factor here. Go ahead, Anthony. Thank you.
Do you have a driver's license?
Yes.
Where is it at? Get it for me.
What other one?
The plate does not belong on this car.
There it is. There it is. First indication of anything that never could have been realized until after he got behind the car. Translation, then why is he following him?
He was looking for something.
He was looking for something. Go ahead, Anthony.
Grab my lighter right there.
I think we all know in the front seat passenger, okay, is a gentleman in the car. And what's really important is you're all going to hear about us talk about that, and the experts talk about that. Why? Because you can't always see what that individual's doing, and that is a danger to police officers. And one thing you will never see in this case is Officer Schuer in any way threaten that person until after the shooting and take any action against that person. What does that tell you? Chris O'Neill would tell you right now. That means that Schuer was not in reasonable fear for his life by that guy. And if he were, then why did he turn his back to him and engage in a physical scrap with Patrick, not knowing where that guy was? It shows you point blank that he was not in fear. Why do I keep using that? That is one of the tests. That is what this case is going to be all about in civil. Because Schuer's going to testify, no matter what happens in the criminal case, he's going to testify he was in fear for his life. And therefore, the civil jury looks at, was he reasonably in fear for his life imminently, right now, this second, when he pulled that trigger? And the answer clearly is no. Go ahead, Anthony, thank you. Here comes the first contact. Door shut.
No. Stop.
Right
Stop. Put your hands right.
Stop. All right. Did he do what the officer wanted him to do? No. But he turned his back and he started walking around the front of the car. He's in the middle of the street, y'all. So it certainly appears to us that he was going around the front of the car and probably going to stand in the grass. He now knows this is going to be an interaction, meaning I'm getting stopped here and this isn't going to be anything quick for me. He did not run. He did not swing at the officer. He did not threaten the officer. He had absolutely simply just turned his back and started walking away. And you'll now see the officer grabbing him. Now, some people think, sadly, that that's okay for officers to do. Other people will tell you he had no reason to touch him at that point because he had no idea what he wanted to do. Some people will tell you, and our experts would tell you, that the number one thing to do right then and there is, where's he going? He's clearly not getting away. I have his car was running. I have his front seat passenger. I've got his cell phone. I got everything in that car, including the plate, even if it's wrong. This guy ain't going nowhere. And he's already radioed, by the way, for backup. So at this point, so many options were available to Schuer other than touching Patrick. But that's not what he did. So he initiated initial contact. Very important. Because he just went from verbal to physical, escalated. This is what we all hear every day about de-escalation. This is a perfect example of if you were trying to de-escalate something you could have done and you didn't do it. So he's escalating now from words to physicality. Go ahead, Anthony.
Stop. 1915. You got one running. Northbound. Stop.
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 Stop. Thank you. So now he's just radioed into his folks for backup. And what you now know, he said, we got one running, and I ask you, one what? One what? When he ran, at that point, there was space in between the people. You're going to hear for the next few minutes about the importance of distance and space with officers and how they're trained. What we're now watching is Schuer, who initiated physical contact, is now initiating a foot pursuit. Titterington, Katsaris, both will tell you something that I think we're seeing across our country, sadly. The increased rate of injury, period, following a foot pursuit is astronomical. It's exponential. And who does it injure? Police, suspects, public. So by initiating a foot pursuit, instead of letting them go, keeping distance, using the car as a block, if you will, some would call it that, and having the wherewithal to know that within 2 minutes, he's going to have backup, this would have been done. Because what you're going to see is Patrick stops running. And watch what happens next. Go.
Okay. Dang.
Stop. Stop.
Okay.
Get your hands behind your back.
Okay.
Hands behind your back.
Stop, please. Now, forgive me for having this redacted. This is all I have still, folks. So Michigan State Police redacted this. I don't have anything else to show you, or I would. So I'm not hiding anything. This is all I have. But this is the type of thing that we will get once we're up and running further. Folks will say, yeah, now he's resisting. Yes, he is resisting. There's no question. It's called active resistance. But if you notice, he's at a defensive position, Patrick, and he's not striking the officer. You've never heard a swear word. You've never heard a threat. You've never seen a gun, a knife, any weapon whatsoever. So obviously Schuer's trying to get him down on the ground now to handcuff him. We'll watch what happens next.
Put your hands behind your back. $19.50. Send more cars.
Send more cars. Back up. They're on the way. Cavalry is coming. Once they know that you've got one running and that there's an officer involved, they come from everywhere. So it's not even minutes away. Go ahead. Stop. If you notice now, they're already down on the ground. Now they're up again. Notice there's no taser pulled. Okay? So it's what's called, the officers are trained in what they call hand-to-hand combat. Peter clearly was just trying to get away. At this point, you're going to see, I want you to notice that, of course, Patrick's pants are falling down, and he's now barefoot. And the only suggestion there is he ain't going far, y'all. Now, you're going to see the officer reach for his taser, and we're going to stop it there. Go ahead.
Stop.
Okay.
Stop resisting.
Notice who's okay, go ahead.
I'm gonna do it to him.
Did you hear the buzz of the taser? I can play it again if you did. So you hear a buzzing of the taser. Taser's called, they call it deploying the taser. This is a special taser. It's a new taser. It's called a Taser 7. This is one of the newest technologies they have by Axon, A-X-O-N. What Titterington said in his affidavit, and Ben Crump will tell you about Ken Katsaris's as well, what you just saw there was a gross deviation by Schuer of his training. When you are engaged in a hand-to-hand combat with somebody or just trying to get hands, if I then go and pull my taser, I now am so close to him, what is he going to do? But push the taser away? Some will argue, try to take it away. Well, I'll prove to you that didn't happen. But, so you don't ever engage with a taser in that, at least in that time. What should happen, Titterington said this, and so did Katsaris's affidavit. The training is, Chris O'Neill will tell you, back up at least 7 feet. You then warn, I'm going to tase you if you don't do what I tell you to do. Maybe use a few other choice words, but you say taser, taser, taser. Why do you do that? Because if people are in the background, like we know there were 2 people watching outside, by the way, and if you miss and you hit them with a taser, you want to give them fair warning, number 1. Number 2, people often, when they hear the taser sound, they think it's a gunshot, and therefore some people will fire back toward the officer and others. So they're trained to give everybody notice. And the biggest thing of all, the reason for the distance, is because when you tase, there's 2 barbs, guys. They're called probes. And when they come out of the taser, 7 feet from the end of the taser to the target, which would be Patrick, you need the probes to hit at least 12 inches different, so a foot apart. Why? Because when they're a foot apart, and if you're closer than 7 feet, they're not going to be a foot apart. They're going to be less. When you get them a foot or more apart, and both of them are in, you get neuromuscular incapacitation. They call it NMI. And that means once I tase and those probes are 12 inches apart, Patrick falls down, he has no muscle control whatsoever, then they go in and they do the handcuffs. So when you heard that they deployed the taser, when Schuer deployed the taser at point blank range, even if the tasers would have been deployed and stuck in Patrick, which they didn't, it would not have received the actual NMI that he was looking for. All of this they're trained on for years before this. He knows this. So to pull the taser up close like that and then deploy it, gross deviations, Ken Katsaris and Tom Titterington said, absolutely, had he followed his training, more likely than not, Patrick probably would have complied. If not, he would have then been tased, he would have fallen down, and the whole encounter over. Yep. Go ahead.
Let go of the taser!
In the affidavit, I'm reading from Titterington, why this is so important about not having the taser up close like that and for not having it 7 feet or more back. Paragraph 14 on pages 5 and 6. As such, my opinion is laid out below. Address all of the above circumstances that would not or should not have occurred, but had Schuer acted in conformity with his training. Accordingly, none of them should be interpreted to mean that it's okay. We're going to talk about everything after this, folks, that will show the gross deviations from tasing. That was actually Katsaris. But what he's saying is, he did all this wrong. It should have been over right there. Over right there. Had he followed his training or just waited for the cavalry to arrive. And that nothing else would have happened to Patrick. Go ahead.
What's the problem?
Let go of the taser!
So what you're going to see now, okay, is the taser. The one that he's yelling at him, Patrick, for trying to grab, even though you can see that he has it in his own hand. What you have to understand is throughout this entire encounter, 2 major things happen, folks. One, there's only one person here who's been trained in taser, but especially taser 7. Sure. Patrick Lyoya had no clue of how that taser worked. That's going to become important later. Number 2, There's only one person who has his finger on the trigger, who pulled the trigger, soon to be a second time, I'll show you that in a minute. That's Patrick Lyoya. Why is that? Because the second time that he pulls the trigger and the barbs don't come out, the probes, and they don't get that neuromuscular incapacitation, the taser ends up being, for all intents and purposes, harmless. Harmless. Go ahead. So this is the actual footage from the front seat passenger to his cell phone. And then folks will say, yeah, Johnson, yeah, Crump, I can see Patrick at various times has his hand near the gun. Yes, but Shure had it in his right hand. He's right-handed. And he's the only one pulling the trigger. So that is who is in control of that weapon. Patrick's trying not to be tased, clearly. And what you can't hear, because the sound goes off, is while he's in this position, stop, please. We're now past the second tasing. It's very difficult to hear. But while they were scrapping on the ground in this location, you will hear, and the Axon representative who testified in the criminal proceeding already cleared up, the trigger was pulled a second time. It did not hit Patrick. Who pulled that trigger was Shure. What's that mean? I know, see Chris Bonilla, you already know. That means the officer, the only one trained in taser, knew that his taser could only be used for one other purpose right now. It's called drive stun. Okay? Drive stun. What drive stun simply means is that you have to get contact with skin, and on the end of the taser, if I pull the trigger and it's touching Ben's skin, Ben gets a shock, but not neuromuscular incapacitation. Translation, he's going to go, ow, but that's it. It is not, in that type of a situation, a deadly weapon. Now, why haven't you heard that yet from anybody? Why are they arguing he's fighting over the taser when the taser was meaningless? And I'll tell you why it's meaningless. Patrick Lyoya would not have been able to turn it on, let alone drive stun, because he's never been trained on either one, while a cop is right there next to him. So this taser, talk about a red herring, we call that in the law. In other words, baloney, okay? It was not a deadly weapon, and it absolutely did not justify what you're now going to see, and that is while Shure is on top of Patrick, him reaching back with his right hand. Next item that no one's addressed for you yet. How did Shure reach with his right hand when he was the one that had his hand on the trigger? Because after he pulled the trigger of the taser the second time, Shure let it go because he knew that there's nothing really that was going to happen bad to him, because he knew my client didn't know how to even do the drive stun. So then why did he pull his weapon? Why did he pull his firearm if we know that taser is all but meaningless? And the answer is to kill Patrick. Go ahead. Now, again, I didn't redact that, but if you couldn't see that, at least you try for it. You can literally see the gunpowder and gun smoke coming out. So, according to expert Titterington, this use of deadly force, by definition, was illegal and excessive because they were not fighting over a taser that could have done any harm to Shure, and that therefore the training would have been as follows. It's all in the Titterington affidavit. Would have been, at the very least, if he wanted to, he could have simply gotten off Patrick, as we can see that he can do, gain space, and if he elected to, he could pull his firearm, he could point, and what would he have to do? Warn. Warn. So neither one of the two tasings before they were deployed was there warning, violations of training. firearm, deadly force under the law, Chris O'Neill would tell you, you have to give warning. I am going to shoot you dead if you come anywhere near me right now. If you don't do what I tell you to do. And both Titterington and Katsaros talked about, had that been done, there is no indication that Patrick would have charged this man. He never did. All he was trying to do was gain space and try to get away and not be beaten. So, by definition, the deadly force was not justified because the officer was not in reasonable fear for his life because he knew that taser was all but rendered useless.
Okay. All right. And I'll go quickly through some final points, and we will have Peter Lyoya, Patrick's father, make a brief statement to you, and then you can ask your questions. And Attorney Johnson really, in very fine detail, broke down what you already know, because it's common sense. It's common sense. But when it got experts, people who are the most learned people in their field, because we understand when black people are killed by police, there is this instance for people to try to find something to justify it. And so we have to go through an extraordinary effort just to get to trial. And that's what we're doing. So, expert Ken Casares filed this affidavit like the other expert in the United States District Court, Western District of Michigan, Southern Division. And you hear Attorney Johnson and I keep referring to my law partner, Chris O'Neill, because he was a police officer for 10 years and he was a training officer. Ken Casares, in the state of Florida and probably all over the East Coast of the United States, is the training officer for police departments. And understand, he normally doesn't agree with us on cases. He's normally testifying for the police department. So when expert Ken Casares and I agree on the use of force against a person, you know it's pretty clear, because they normally justify why it was acceptable for the police to kill the black person. But in here, he says no way. And so I'll run you through a few of his points. First of all, it's important to know that he is an instructor on the use of electric controlled weapons, ECW. He was certified as an instructor for Taser International, which is now Axum, as Attorney Johnson talked about. That's important because he's teaching people how to use tasers and making sure that they get their certifications every year to be able to use those tasers. He also was one of only 50 experts from countries throughout the world to evaluate the standards for ECWs by the National Institute of Standards. This is heavily relied on by Taser International and everybody else in the industry. His first opinion that I think is of note, and you'll have them all, you can decide what you all think is germane. But he talks about, while pursuing Lyoya, after he realized he could not control Lyoya with verbal commands or physical interventions, Officer Schur failed to create distance of at least 7 feet. And it's exactly as Attorney Johnson explained it. When you're going to use a taser, you got to have distance for a myriad of reasons, the natural reaction, but also you want the taser to be effective. And you know it's human nature. If I came to you and I put a taser within a few inches of you, you're going to try to not be tased. That's just a human instinct that everybody understands. He then talked about, as he laid out the below circumstances that would not and should not have occurred had Shearer acted in conformity with his training. That was significant. He interpreted that to mean that Officer Shearer wasn't justified. He wanted to say, even if he followed the training, there's nothing that would have justified his use of any force in this matter. He went on to say, and we're going to get to the good stuff in a minute, in my opinion, that Officer Shearer was less interested in properly using his department-issued tools as he was trained to do, and more interested into having constant physical contact with Lyoya. And you see that through the video. I mean, he is coming on him, even though he doesn't know he have a weapon. He doesn't know who he is. But as Attorney Johnson said, you have to reasonably conclude that he believes he has no weapon. Because if you thought somebody had a weapon, you wouldn't just walk up on them. Again, this is common sense. But we got this expert of 40 years, this former police chief, this former head of curriculum for Florida Department of Law Enforcement, this person who helped train federal agents tell us what our common sense already tell us. You don't approach somebody if you think they got a weapon. He then said, contrary to his training, Officer Shearer improperly used dual force by physically engaging Lyoya while using the taser. One or the other. You should not go hands-on, but if you're going hands-on, why are you getting that close with the taser? He said, I see no video evidence to suggest that Lyoya actively took the taser from shore or otherwise has physical control of the taser at any point. That was important. He talked about, as Vince said, since the taser could only be used in a drive stun mode before drawing his firearms, Officer Shearer should have instead sought to create distance and seek out barriers between him and Lyoya. And that was because, at most, if Lyoya knew how to use it, all he could do was touch the officer. He wasn't in fear of his life. Now, this is the important thing. He said it was unnecessary, objectively unreasonable. We're going with the legal buzzwords now. And a violation of Officer Shearer to draw his firearm and shoot Lyoya in the back of his head while straddling Lyoya's back, based on the totality of the circumstances. Officer Shearer, nor any reasonably trained officer similarly situated would have reasonably been in imminent fear of his life or the life of another. Hence, the shooting was not justified. He also talks about the city of Grand Rapids. He said, by operating in this fashion, the city of Grand Rapids has sent a message to its officers, including Officer Shearer, that Officer Shearer's conduct, as described above, was not inappropriate, according to police command.
Can I make a statement of that? What he's talking about there, folks, is after these events, you recall, police chief, and thanks to Commissioner Womack, came out that Friday, so about 4 days after the shooting, and held a press conference. And the chief of police was very critical of Shearer, and you could tell by the words that he used that he thought this was going against the officer. And then what happened was the city of Grand Rapids did nothing but put him on administrative paid leave for the next 2 months Let me say that again. No discipline, no internal affairs investigation that's been made public, and no public, if you will, findings that what Schuer did at various points was against their own policies and procedures, such that when Prosecutor Becker, who is a county employee, not a city employee, charged him with second-degree murder, this officer was still an employee of City of Grand Rapids. Thus, that's when they fired him, and what I know you all don't know, because I don't know, they fired him and he waived a hearing. So what did he agree to? What did they give him as part of his termination package that we don't know about? I don't have that answer, but I'll get it for you and I'll tell you. But that's what these guys are now talking about. It's called ratifying the bad behavior. City of Grand Rapids is saying, Mr. Crump, go ahead and do this, even though we say you're not supposed to use this force, but if you do, we'll take care of it. Sorry.
Attorney Johnson took expert Kasar's thunder. Furthermore, no, thank you for making it plain, as we say in the Baptist church. Furthermore, there's no indication that the city will have disciplined Officer Schuer for compromising his training had he not been criminally charged, as Attorney Johnson just said. This conduct by the city epitomizes deliberate indifference, another legal word, and was a substantial factor in why Officer Schuer's excessive force in this instance was not condoned. He states, lastly, it is my opinion that a reasonable officer in Officer Schuer's position, considering the totality of the circumstances, would have known that the shooting of Patrick Lyoya in the back of his head while Lyoya was prone was a violation of Lyoya's constitutional right to be free from excessive force in light of a relatively minor crime Lyoya was suspected of. Lyoya, he concluded, posed no imminent threat to Officer Schuer or anybody else. And from all the evidence, and Lyoya's acts of resistance were limited to attempts to simply get away from Schuer. So you dropped the mic on that just to simply common sense. Common sense. These experts was painstakingly technical in filing their affidavits with the court. But for people in Michigan and people in the United States, there is no constitutional right to execute a black man by shooting him in the back of the brain for him simply trying to get away from you. Common sense. Mr. Lyoya, do you want to briefly say a word about the family?
Ndio, mimi ni baba yake ya Patrick Lyoya.
Yes, me, I am Patrick's father.
Basi kufika hata kwa tarehe ya leo, nina uchungu sana mimi na familia yangu kwa ajili ya kifo cha Patrick.
Even to make it to date today, I'm still in pain, me and my family, for the loss of my son Patrick.
Patrick ilikuwa inafika mwezi wa pili tarehe 5 ya kila mwaka ndo siku zake za kuzaliwa.
And Patrick, every time when it was February 5th, it was his birthday. That was the time that he was born.
Sasa ile siku imefika, Patrick hakuonekana, Patrick aliuawa.
And that day when he came, Patrick was not around, Patrick was killed.
Ile ilituletea uchungu kama familia yote, wadogo zake, mimi baba yake na mama yake tumesikia tumeumia sana wakati ile tarehe imefika.
And that also brought us a lot of pain again. Me, his mom, and all his sibling, brother and sister. When it came to February 5th, it was so painful to us.
Basi mwezi huu wa 4 tarehe 4 wakati umefika ndo ulikuwa tena ukumbusho wa kifo cha Patrick.
And then on April 4th, this year, it was again the remembering how I lost my son.
Kuliko kusherehekea siku ya kuzaliwa, sasa imekuwa ni kwenda kuangalia kaburi ya Patrick hii mwezi ya 4 tarehe 4.
Besides us celebrating the day that Patrick was born, now it has become for us a customer to go check Patrick's tomb where he was buried, because on the 4th of April, it was the day that he was killed.
Tunaumia sana.
We are hurt.
Wakati tumeenda kaburini kwa Patrick tumeumia sana.
When we went to the tomb, we went to the cemetery, we were hurt, wounded.
Kwa kifupi, kuona Patrick ameuawa, amefikisha mwaka, na ule ambaye amemuua ule muuaji, polisi, angali nyumbani kwake, analala kwake na watoto wake na mke wake. Lakini Patrick iko ndani ya kaburi.
In short, Patrick has been killed, and when I think about the officer, the murderer that who murdered my son, and is at home with his wife and children, and Patrick is buried, that hurt.
Kulingana na gisi tunajua hii nchi ya Marekani na kufuatana na sheria, hatakuwa tunajua kama Patrick anaweza kumaliza mwaka mzima bila kupata sheria ya Patrick gisi ameuawa.
The way that I know this country and the law and the justice in this country, I never thought that it can be for the entire year for Patrick not receiving the justice that he deserves.
Wanaendelea kusukuma mwezi ya 3, mwezi ya 6, mwezi ya 10 kwa kutafuta kusahaulisha kifo cha Patrick gisi ameuawa.
They keep pushing the case, March, June, October. All of this is just because they want the people to forget how Patrick was killed, how my son was shot in the back of the head.
Hii yote tunajiuliza sisi watu weusi, sio kwangu tu juu nimetoka Afrika, na kwa mweusi pia mwenye yuko hapa. Ingekuwa Patrick alikuwa mzungu, kweli hii ingeendelea kusukumiwa mpaka hadi kwa leo hakuna sheria yoyote imeamuliwa.
And this is the question that we are asking as black, me as a black person, not just because I came from Africa, but the black people here too. If Patrick was white, the question is this: if this thing was going to take this long before he gets justice, I don't think so.
That's good.
Ingekuwa Patrick yeye ndo amemuua ule polisi, kweli Patrick leo angekuwa iko nyumbani?
And the question I'm asking, if Patrick was the one who shot the police, the officer, Patrick was going to be at home today?
Kwa kweli inatuzungumisha sana, tunaomba sheria juu ya Patrick.
And it's really hurting, and we are asking justice for Patrick.
Kama hii nchi ina sheria, tunaomba sheria ionekane juu ya Patrick. Tunaumia sana.
If there's a justice in this country, we are really asking justice for Patrick because we are really hurt.
Thank you, Peter.
Asante sana.
Thank you.
And I'll just say this real quick. People may ask why we keep drawing attention to the fact that this was unarmed black man shot in the back of his brain for a simple traffic stop. And the reason we keep bringing it up is we never see videos of the police shooting a white person in the back of the brain for a traffic stop. And so if it's not acceptable for police to do that to white people, why do we try to justify when they do it to black people? And when you think about that, Attorney Johnson, as Commissioner Womack reminded me, that this happened on April 4th, which was the same day that Martin Luther King was assassinated. It really begs to question how much progress have we made in America when it comes to equal justice.
Alex, questions?
Mr. Johnson, Mr. Crump, you guys are alleging in a civil lawsuit excessive force and violation of rights, right?
Yes.
Are you seeking a jury trial?
Yes.
Okay, question for you. For each of those allegations, which bar is gonna be higher to prove, given the video evidence that you have and the expert testimony that you're gonna get in the trial? Which bar? Is it easy to prove that the officer violated his training, or that Mr. Lyoya civil rights were violated? You mentioned earlier about people trying to justify.
Yeah, and I'll go first, and then I'm sure Attorney Johnson will opine. But I think one begets the other. I literally think that the videos support all the opinions of the expert, and the opinions of the expert are all backed up by the video. And so you can just take the training, watch the video, and you can check off, he didn't follow this training, he didn't follow this training, didn't follow this training. And before Ben goes, I just don't want to have it get lost. That is common sense, that they use this type of excessive force against certain citizens. And oftentimes, everybody tries to wipe the blood off their hands and justify it. You cannot wash Patrick Lyola's blood off of Officer Shore's hands, nor can you wash it off the city of Grand Rapids' hands, because they not only tried to condone this, but for the prosecutor, he would have got away with murder.
Which is exactly what the captain said in the preliminary exam. Grand Rapids Police Captain was called by the defense for Shore and testified Shore did nothing wrong. And then, of course, Becker, in cross-examination, said, then why did you fire him? And the answer is because you charged him.
So,
I mean, come on, y'all. What else do you need? I'm sorry,
Question.
Lauren.
for both attorneys, Attorney Johnson and Crump, thanks so much. Lauren Edwards, Fox 17. You mentioned when you reached out to them, but how long did it take the experts, the police experts in all of this to gather this information and put it all together and make their conclusion?
Well, we hired them within 2 weeks of the shooting, and then we sent them information, but as information gathers, Lauren, we send it to our experts. So I'll have more information in a year from now than I will today. But all the videos that they've seen, the Michigan State Police report that they've seen, Michigan State Police redacted Schuer's witness statement, so I don't even have that yet. So I'll get that. We have some parts of the Grand Rapids, what we think is an internal investigation that was turned over to MSP. So we have a great deal of information, but it will be more. But to answer your question directly, they've been working on and off on this now for a year.
I guess this is a legal question. Where is the line for qualified immunity? Where, I mean, like, is this it right here where you can show that there was, you know, he did not follow procedure, or?
Great question.
Yeah, and you see me holding my hands up because it seems to be, no matter how compliant or how obvious it is that the person, especially a black person, isn't posing a threat to the police, they always say, I had to kill him because I felt in fear of my life. They said it with Patrick Lyoya. They tried to say it with George Floyd. They tried to say it with Tyree Nichols now. And you see this video that's just a contradiction of the words. Attorney O'Neill often talked about in training, and you heard some of that there. They start saying, quit resisting, quit resisting. That's the same thing they said in Tyree Nichols. That's the same thing they tried to allege in George Floyd. So in every instance, this qualified immunity allows police officers to kill black people with impunity. And that's why we have to fight so hard to get simple justice, even though our eyes see the truth.
So here's the standard. A reasonably prudent officer ensures position. Would they know that the shooting of Patrick Lyoya in the back of the head in this situation was illegal? In other words, under the law. And Tennessee versus Garner, y'all, is a case from way back when the United States Supreme Court ruled you can't shoot somebody because they're resisting and trying to run away, okay? So we say the answer to that question is obviously yes here, but to get to your question, here's how it really works. This is not a jury question. Qualified immunity is a question of law for Judge Maloney, and then whatever he rules, if he rules in our favor that he's not protected by that, then they will appeal to go to the Sixth Circuit Court of Appeals, and then 3-judge panel will either say, yes, qualified immunity applies, and Schuer just walks away, Johnson and Trump, your lawsuit's thrown out, or no, we agree with Judge Maloney that there is no qualified immunity for this. So to answer your direct question, it's whatever the federal district court judge rules it is, and what the 3-person panel, Sixth Circuit Court of Appeals rules. Not a jury question, ever.
And understand, 4 years ago, the statistics were that 97% of the time when police officers said qualified immunity, federal judges accepted it, no matter what evidence we had. And so I think, my God, in the last 10 years of Turn On Near, we must have bought at least 200 police excessive use of force cases where people were killed. And you would be utterly shocked to see what district courts said were justified. All these black men running away, shot in the back, they all said it was justified to shoot black people in the back. And it happens over and over and over again. And to Mr. Lyola's point, if it was a white citizen that the police shot in the back of the head for a minor traffic violation, I don't think anybody would have to worry too much about qualified immunity. I don't think anybody would have to worry about the city of Grand Rapids firing him immediately. I don't think anybody would have to worry about him being charged to the full extent of the law. But when it's black people, we come up with these technical justifications to say it's okay to shoot them in the back.
Did I answer your question? I know it's hyper-technical, I'm sorry, but it's a governmental immunity situation.
When are you expecting that ruling?
It's a great question. Judge Maloney will typically, now that we have our papers filed, will give us a hearing date, which of course we will share with you all. Unfortunately, it's federal court, so they don't let cameras in, but it is a public setting. So when we get that date, I will be happy to share it.
And you're allowed to come in, not with cameras, though.
Ben, Arpan Lobo, Detroit Free Press. You've spoken about the Grand Rapids Police Department's responsibility. In the last year, they've instituted new training policies and policies on the sanctity of human life. Do you feel that this is a strong enough step to push back against excessive force usage?
I'll defer to Commissioner Womack, but you know my answer is no.
Well, you know what I'll say, and then Commissioner Womack, as one of the leaders in Grand Rapids, he is probably the most pronounced voice on this. But it's interesting that you always come up with these policies after the fact, but then you think about all the policies they had in place before. And if you don't hold the officers accountable, then they're just dead words on paper that mean nothing. And that's what we see in Grand Rapids and other places. It's just dead words, but when they need to apply, the officers don't pay attention to them because the pattern is, we're going to cover you no matter what.
Thank you, and Kent County, Honorable Kent County Commissioner Robert S. Womack. Thank you, Van, and Mr. Crump. When you ask if that's enough, you have to look at the history of Grand Rapids. The Michigan Department of Civil Rights came to Grand Rapids almost 4 to 5 years ago and held hearings to hear from people, and hundreds of people came and made complaints. The Michigan Civil Rights Department of Michigan also filed complaints against Grand Rapids when it comes to policing after their investigation, and some of that litigation is still going on. So there was a pattern that led to this shooting. And before we even get to the shooting, I myself have been a victim of the U-turns on African Americans for driving while black. So as Van pointed out in that video, he couldn't see a license plate. You're driving down the street, they see you're black, and you're hoping, praying they don't make a U-turn and turn around on you. For me, 7 out of 10 times they make that U-turn. And sometimes they'll just go. Sometimes they'll pull you over. I think the last time I was pulled over was for a tail light a month ago. But the driving was this way. It had to be a U-turn. And it was in the greater Grand Rapids area, not actually in the city. When you talk about quantified immunity, they say we're free now, but it was quantified immunity for the slave masters to treat us like animals and stock. So in Grand Rapids, we are so thankful that these attorneys have taken this case. We're so proud of the Lyoya family for standing up, because we live under that national oppression that African Americans live across this whole country. And these are the things you may hear now and be a little shocked that I'm saying, but these are the conversations that are in barbershops and in churches and places, and people are afraid to jump up and say it out loud, because you can be politically lynched. You can be politically executed. You can lose your job at a place where you work. You can lose sponsorship if you're an athlete. You can lose sponsorship even if you're a school principal. You can hurt your entire school by saying some of the things that I'm saying. It's political suicide, financial suicide, but we have to stand up so the children of tomorrow, both black and white, of all colors, can have Dr. Martin Luther King's dream, where we are walking hand in hand, and people won't have to make these same mistakes because they're being taught by the government, the city of Grand Rapids, and people, as Vin said, the chief said that this was great behavior. So that's a bad message to the youth of tomorrow. I hope these attorneys are successful, because I think it's going to make a brighter day for everybody when we can turn around some of these injustices and get on the right track.
Thank you.
Thank you.
Question from Kara Berg, Detroit News. The experts' affidavits are remarkably similar. Were they given questions to answer about the shooting, or did they write down their own thoughts on the video and Scher's actions without guidance?
Well, Carol, it's interesting that you think they're close when they're two different people that did them. So I don't quite understand your question there. The answer is it's one factual pattern. There's only so much you can talk about given the evidence, so.
Yeah, and I'll just say, Ben knows the other expert better. I've had cases against Ken Casares. He is not going to go against the police unless it's clear that he testifies for the police far more than he testifies for plaintiffs.
Follow-up question from Kara. Did Scher's legal team have any expert testimony or affidavit saying Scher's actions were acceptable?
I'm sure they
Well,
will.
they had the captain from the Grand Rapids Police in the preliminary exam, but that's the criminal case. They attached nothing to their current motion on behalf of any experts. What they attached was, or actually didn't even attach it, they gave a factual recitation of the video, but that's what the lawyers say happened. I don't want to hear what lawyers have to say. I want to hear what the experts that actually do this have to say. That's why we did expert affidavits.
Last question, or last call for questions in the room or on Zoom.
Thank you.
Seeing none, thank you.
Thank you, everybody.